Welcome to the NCSL webinar, Recidivism Reduction and Justice Reinvestment. My name is Megan Dorsch, and I'm going to be moderating this webinar over the next hour. We're glad that all of you could join us today. We'd like to take a moment to thank the Bureau of Justice Assistance in the Office of Justice Program, U.S. Department of Justice, and the Public Safety Performance Project of the Pew Center on the States. The NCSL Criminal Justice Program has an ongoing partnership with both of these organizations that focus on corrections, sentencing, and reentry policies. Successful corrections and sentencing policies result in recidivism reduction and cost savings. Today, you are going to learn about findings from the recent report, State of Recidivism, the Revolving Door of America's Prisons, including crime and recidivism rates, how policies affect recidivism, and strategies in states that have resulted in decreased recidivism. The webinar will provide an update on the Federal Justice Reinvestment Initiative, including a look at states that are currently in the process of reinvestment reform. And finally, you are going to hear from legislative staff about their experiences in the justice reinvestment process going on in their state. Our presenters today are Ryan King from the Public Safety Performance Project of the Pew Center on the States, Dr. Nancy Levine with the Urban Institute, J.J. Gentry from the South Carolina General Assembly, and Douglas Holbrook with the North Carolina General Assembly. Together, the presentations are expected to take 50 minutes and will be followed by a question and answer period. You are welcome to submit written questions at any point in time throughout the presentation using the chat box. Time permitting, we will get to as many questions as possible during the Q&A session, and we'll follow up on any unanswered questions after the program. An archive of this program, including all of the PowerPoint slides, will be made available on NCSL's website. Our first presenter today is Ryan King. He is the Research Manager for the Public Safety Performance Project of the Pew Center on the States. The Public Safety Performance Project was launched in 2006 to help states advance fiscally sound, data-driven policies and practices in sentencing and corrections that protect public safety, hold offenders accountable, and control correction costs. The project provides expert, nonpartisan technical assistance and produces reports on effective policies and practices. Mr. King was the lead researcher for Pew's recent report, State of Recidivism, the Revolving Door of America's Prisons, and he's going to spend just a few minutes talking with you about the findings in this report.
Thank you, and good afternoon to everybody, and good morning to folks on the West Coast who have a few moments left of the morning. It's a nice opportunity for me to talk about this report and with a good audience of people, so I appreciate you taking an hour out of your busy day. I just wanted to give a really brief overview of the study and our findings, and then spend a few moments kind of talking about some of the factors that we identify in the report as driving recidivism in the states. Before I dive in, I want to start by giving kind of a general overview of why we did the study. I think first of all, because a lot of people will be aware, recidivism conversation nationally has been governed by national numbers. I mean, the two main reports we have out there are the Bureau of Justice Statistics reports looking at recidivism rates of release cohorts from 1983 and 1994. And those are the numbers that we have traditionally used when discussing both national as well as state policy around recidivism. And of course, when you rely upon national numbers, you are largely obscuring interstate variation. And so we recognize the importance of understanding these recidivism measures to policymakers in the states, and wanted to make an effort to go through and actually collect state-level recidivism rates from all the 50 states and take a look at variation over time and across states. And I think most importantly, from a general standpoint, we wanted to move this discourse beyond the numbers. I think a lot of people are familiar with numbers such as 2/3 rearrested within 3 years or half returned to prison within 3 years of release, and it's usually the beginning and the end of the conversation about recidivism, and we thought that really should just be the beginning, and that we need to spend a lot more time talking about what the factors are that drive recidivism, because these are the sort of things that policymakers and practitioners need to know when they're thinking about putting in place policies that can lead to reductions in recidivism. So first slide here, which everybody should be looking at, is a study overview. As you see there, it's a first-of-its-kind survey of a 50-state survey of recidivism measured as return to prison. We took data from offenders released in two cohorts, 1999 and 2004, and we followed them for 3 years. Now, I recognize that there are a lot of issues in how states define recidivism, and I think it's later on I'll talk a little bit about how we measure recidivism and ways that we think recidivism should be measured as a sort of more accurate performance measure. States reported recidivism for both new crime and technical violations of supervision. I would just sort of say then as a final caution that the differences in the definition and the data collection procedures definitely warrant caution about making interstate comparisons. So I will sort of dive into that a little bit as I move along. So generally, while spending is up, recidivism rates have remained stubbornly high. Nationally, as you can see on this slide, 4 in 10 persons released from prison are returning within 3 years. And we argue that this number has been largely stable since the mid-90s. Now, let me give a little bit of context here, which I think is really important. Now, you're likely familiar, as I mentioned earlier, with the BJS numbers of 2/3 being rearrested and about half returning to prison within 3 years of release. Now, our numbers differ for a number of reasons. One is that we include more states. We received responses from 33 states for the 1999 cohort and 41 states for the 2004 cohort. So the BJS samples were, for the 1994 study they did, were 15 states, so we have more states. And there are also some methodological measurement differences that we talk about in the report. But I would actually say these numbers do show some more consistency than you might think from just looking off the top. When you exclude California from our analysis, and when you exclude California from BJS's analysis, you get recidivism rates for both their 1994 cohort as well as our 99 and 2004 cohort of around 40%. So California, unsurprisingly, has a disproportionately large impact on national recidivism rates. And so putting all that together, it suggests that our measures that we have here in this report are pretty similar to what BJS has, and I think it also underscores the need to study and understand state-level trends. Exploring trends in the states allows us to better understand the policies and practices that drive recidivism rates, as well as highlight successful strategies that have been proven to be effective at reducing recidivism. And these include the use of sophisticated risk assessments, meticulous reentry planning, and post-release supervision that's carefully tailored to each offender's circumstances, as well as the use of graduated sanctions to respond to violations. So the next slide here will give you a general overview of the nation. These are changes in recidivism between the 1999 and 2004 cohorts. As you saw on the slide before, the 3-year rate of return declined from about 45.4% to 43.3% between the 99 and 04 cohorts. But as you can look at this PowerPoint, you can see that states across the country had very different trends. And I want to, again, caution you, and I'm about to dive in a little bit more, but I want to caution you against sort of looking at one state and another and looking at the changes in the trends, whether they're increases or decreases, and assuming that those automatically are indicative of either effective or ineffective policies. So there are a whole bunch of underlying factors that I'm going to spend the balance of my presentation going into, but I'll give you another moment to look at these. I think the main takeaway point from the graphic here is to get a sense of the variation from states, both in the direction of the trend, whether decreases, increases, as well as the scope of the trend, and recognizing that I think one of the points we really wanted to make with this is that recidivism is very much a state issue, and the policies and practices that exist in states have a significant impact on recidivism. I'm going to move to the next slide here, and you can get a look at cost savings, just a way to sort of illustrate if just the 10 states with the greatest potential cost savings, and that potential cost savings is a function of both recidivism rates as well as their annual cost of incarceration. If that was just reduced, if those states could reduce their recidivism rates by just 10%, and then were able to close facilities as a result, they could save more than $470 million in a single year. So there's significant amount of savings that can be realized by states by implementing policies and practices that reduce recidivism as little as 10%. And I think that's something that you'll hear more of in this call, and it's something that is critically important to get a scope of how significant these savings can be. Now, these numbers that I've been sharing with you are impacted by more than you might think, and I think it's critical to underscore that very high recidivism rates are not necessarily indicative of bad policy. for lack of a better term, and very low recidivism rates are not necessarily indicative of good policy. I have a slide here that I'm going to walk you through to give you a sense of, at all stages, from before an individual enters the system, while they're behind the walls, as well as reentry, the different policies and practices that impact recidivism. At pre-entry, there's sort of key questions. Are states using a validated risk and needs assessment tool at intake to identify potentially urgent needs? One example we talk about in our report is in Oregon that inmates were receiving risk and needs assessment at intake, and this helps establish targeted case management during incarceration, and is a practice that state has identified has been successful in bringing down their recidivism rates. The risk profile of offenders will also vary significantly from state to state. And this is governed by a number of factors, including state sentencing laws. If a state is sending lower risk people to prison, people who may end up in the community in other states, then the recidivism rate is likely to be pretty low. An example we use in the report actually is once again looking at Oregon and Oklahoma. And those are two states that in our report actually had pretty similar recidivism rates, both quite low. Oregon has put in place a number of evidence-based policies and practices to address recidivism, and so they believe that those low rates of recidivism are a result of those interventions. In Oklahoma, they actually have a prison population that folks we spoke with there suggest have a number of low-risk people in prison. Oklahoma, again, this is coming from within the DOC in Oklahoma, argues that by having low-risk people there, they essentially have people that were at lower risk of reoffending coming out. And thus their recidivism rate is low, but may have less to do with sort of effective evidence-based policies and practices, and a lot more to do with who they decide at the front end to send into prison. And on the opposite end of that spectrum is a state like Minnesota that had a particularly high recidivism rate, and their response was that they're preserving their prison space for the most serious offenders, and those are offenders that may also have particularly high-risk profiles. So you can get a sense about both what happens before people go in, as well as who you put into prison is very much going to have an impact on recidivism rates. The second middle column you see there is the behind the walls column, and you'll notice again that assessment is present there as well. Again, remaining an important factor, assessing individuals when they come into prison, assessing them while they're there, and of course classification practices as well while people are incarcerated. I want to focus on the transition planning component of the behind the walls column. While in prison, offenders really should be developing relationships with parole officers and others who will be integral to their success upon release. So this is sort of getting, if states have in place practices where they're engaging with people while they're still incarcerated and not waiting until the last minute or the last few weeks to prepare people for release, you can expect to have better outcomes in recidivism. Release criteria, also a critically important factor as well, how states are choosing to release people, who's being chosen for release, and of course programming the programs that are available for individuals. That's the key point for assessment, is assessing people's needs and then being able to pair them with the types of services that would be necessary. These are factors that we see as having a positive impact on recidivism. And I do have what I would really like to see, actually not in the third column, but really sort of over the arrow between the middle and right column, which is reentry handoff. But this is a critically important point as well. And from coming out of the transition planning, which is the sort of practice of handing off responsibility for an offender once they're released and out into the community. In Michigan, as an example, we talk about in the report, prior to parole, offenders are transferred to a reentry facility, and the transition plan, including things such as housing, employment, transportation, and services, is finalized in collaboration with community service providers. Other elements under reentry that we think are important, and once again, you'll see the importance of assessment and classification. A validated risk needs assessment and matching an offender to the appropriate level of supervision is critically important. The duration of supervision while somebody is in the community. States with shorter periods of supervision are likely, unsurprisingly, to have lower rates of revocation. In a state like North Carolina, supervision is unusually short. It's about 6 to 9 months, and so not surprisingly, North Carolina has a particularly low rate of technical violations relative to other states. And then a key point is, how do states detect and respond to technical violations? And those are influenced by a number of factors: the caseloads for folks working in the community, the rules that offenders have to follow in a state, the availability of drug testing, GPS and other technological monitoring, and then supervision philosophy. A state that we talk about in the report is Missouri, that had particularly high rates of recidivism in our report, and these rates were being driven by technical violators, and Missouri recognized the technical violation issue when they were able to look at their data, and is bringing down their TV rates by relying upon risk assessment and intermediate sanctions. So this is an example of a state that identified a problem and then that is intervening and trying to put policies in place to address it. So all of this slide, I think, if you walk away understanding that, once you see a recidivism number, that shouldn't necessarily be the end of the conversation. That should really just be the beginning. And whether it's high or low, it's important to understand what is driving that recidivism rate. And this slide, I think, gives you a handful of examples of the different places that you'd probably want to look at first. So the trends that we see here have started long before the economy sunk, but tight budgets, I think, have certainly accelerated the demand that public programs produce better results. Recidivism rates are and will often be the way policymakers and the public assess the performance of correction agencies. So it's really critically important that we accurately measure recidivism in order to really assess the correctional performance. And I think this requires defining recidivism reduction as a goal of corrections performance. We also need to really agree on a common definition of recidivism. And so that includes not just sort of is it return to prison, is it rearrest, is it reconviction, but also understanding that recidivism is going to vary a lot based upon some of these factors we've gone through here. So we actually argue for creating, let's say, risk-adjusted recidivism rates. This is one sort of bit of analysis that we're trying to do now, which is to actually look at the profile of people in prison, look at risk, and then create risk-adjusted recidivism rates. And then these actually will help us define achievable performance goals. So it's one thing to say, let's drop our statewide recidivism rate by 10%. It's another thing to go through and sort of begin to divide up cohorts of folks based upon certain factors, and most importantly, their risk rate, and then develop performance measures coming out of that. And so I think this is both a function of having to go through and have a conversation about defining these things, and then, of course, most importantly, collecting the data necessary to measure progress toward achieving those goals. And I would argue that if we combine these right measures with the right policies and programs, we'll be able to save tax dollars and make our communities much safer.
Thank you very much, Mr. King. We also have Richard Jerome, who's a project manager with the Public Safety Performance Project, on the line, and he will be available to answer questions at the end of the presentation if there's time. Mr. Jerome oversees Pew's technical assistance work in the state. Next, we're going to hear from Dr. Nancy Levine. Dr. Levine is the director of the Justice Policy Center at the Urban Institute, where she oversees research projects on prisoners' reentry, crime prevention, and the evaluation of criminal justice technologies. The Urban Institute coordinates activities for the Bureau of Justice Assistance Justice Reinvestment Initiative. Dr. Levine is now going to discuss the Justice Reinvestment Initiative with you all this morning. Dr. Levine?
Hello, everybody. Just going to forward this slide here. Thank you very much for joining in on the webinar this afternoon. It's my pleasure to be presenting on the Justice Reinvestment Initiative. My goal today is just to describe the impetus behind justice reinvestment, what the justice reinvestment model looks like. I'll describe a little bit about what's going on in the states, and then describe the larger justice reinvestment initiative that's being run by the Bureau of Justice Assistance. And as noted, the Urban Institute is involved in that effort. So first of all, what do we mean when we say justice reinvestment? It's kind of a difficult concept to define because it involves multiple steps. But the ultimate goal behind justice reinvestment is to be more cost efficient in criminal justice expenditures. So it's designed to help states and localities that I think universally across this country are struggling with trying to maintain public safety amidst a serious budget crisis. They have, for the most part, shrinking budgets, and yet a steady flow of people entering both prisons and jails at a great cost. And so it raises questions about, are there other ways to do business, and can those other ways achieve similar, if not even greater, public safety goals? In essence, these jurisdictions are asking themselves, what can we do to reduce costs while preserving, if not increasing, public safety? So what can justice reinvestment accomplish? Certainly it's important to focus on public safety, even if the impetus behind these initiatives are primarily economic. The bottom line is that the state and local policymakers are interested in public safety, and yet prioritizing the use of confinement for the most serious and dangerous offenders is not commonplace, or hasn't been recently, and doing so can really both save money and increase public safety, while diverting people who perhaps need not be in confinement to community resources, community supervision. Obviously, an equal goal is the cost savings that I referenced already, and those can be achieved by much of what Ryan was describing earlier, various efforts to reduce recidivism, reducing both reoffending as well as reducing repeat admissions to prison and jail that may or may be caused by reoffending or by violations of probation and parole. Locally, there's an interest in reducing the number of detainees in jail settings who are unsentenced and awaiting trial or other disposition. Do they all need to be behind bars? And several states have unified systems, so this applies to them. And then, of course, increasing efficiency to incur cost savings as well is another strategy that can be employed, and that involves greater coordination across the criminal justice system instead of the siloed situations we often see in states and localities. So how does this work, justice reinvestment? Well, it involves a great degree of upfront work involving the collection and analysis of a wide array of data that can help identify what the drivers are of criminal justice system costs. And by drivers, I mean primarily, if you look at the biggest chunk of criminal justice costs, it tends to be correctional confinement. So answering questions like, who is getting a prison sentence? How long are they in prison? Why are they released? When are they released? Who ends up returning? Under what situations? What are the needs of the people who are behind bars? What are the risk levels of those individuals? Answering those questions can go a long way to understanding what the drivers of system costs are and what alternative strategies could be put in place that could reduce those costs while maintaining public safety. So this involves not just identifying those drivers, but then reviewing those drivers in the context of a collaborative body that includes all the significant criminal justice and state, and in the case of local stakeholders, the decision makers, the people who are involved in passing legislation, the correctional administrators, the folks who are in charge of budgets, certainly at the state level, the governor. Really, all these folks have to be at the table together and have a shared vision and interest and goal in doing business differently in a way that can conserve resources while maintaining public safety. So that then, a result of those conversations after identifying those drivers, leads to specific changes that can be made across the system. And again, I don't want to be redundant. Ryan has discussed many of the different strategies employed to reduce recidivism, and those are often the same strategies that are employed in justice reinvestment, and I'll describe a few examples soon. But deciding which of those changes to make, typically on the state level, these changes are codified. They're passed through legislation. They're universally bipartisan. They need to be in order to get passed, but also to have the political will to implement the laws as intended. And these changes are, as you know, intended to yield cost savings. And so in these acts that are passed, there's almost always some share of those savings that are identified for reinvestment into services, programs, and activities that are associated either with the criminal justice system or are located in the communities to which the vast majority of exiting prisoners return or come from. And that is the reinvestment part of justice reinvestment, which is why I was saying at the beginning of my talk, this is a long definition to get to justice reinvestment. But that is why we call it reinvestment, is the goal of not just saving money, but reinvesting some share of those savings into more proactive and preventative efforts. And as I've said already, the ultimate goal is greater public safety at lower cost. This just illustrates the model of justice reinvestment at the local level. This is something that the Urban Institute has worked with 3 counties to apply the justice reinvestment model at the local level. I just happen to have it handy, but I can share with you that the model is very much the same at the state level, and it was what I described to you already. It starts with analyzing and the data and identifying the drivers of the population, developing the strategies. Certainly there's an important component in documenting costs and potential savings, reinvesting the savings into the system and the community. And an important component is also to continually analyze the impact. And in the center of this graphic you'll see interagency strategic planning, and that could be replaced at the state level with bipartisan collaborative support. In the work that we've done on justice reinvestment to date, we've identified some guiding principles for success that I thought I'd touch upon briefly. First of all, the issue of transparency. And I referenced already the need for bipartisan support for getting all the stakeholders at the table. And that is critical to be successful in this type of initiative. And it's also critical that you not only have everyone at the table, but everybody has a voice and they have a shared vision for what they're trying to accomplish. Validity is another important principle for success in justice reinvestment. And where we see validity coming into play is in the use of data and the identification of those drivers that I referenced earlier. Being able to point back to actual statistics that are quite compelling in demonstrating how changes could be made that would be more cost efficient. Far too often when you get these groups of stakeholders together, people rely upon stories. And often they rely upon stories of individual offenders and extreme cases to make their arguments for usually against change. And that's why the validity of having the data to work with and back up decision making is critical. Sustainability is also really important. On the state level, often sustainability is accomplished through legislation that's passed, that's enacted. But in some cases, there are examples of states that make changes to administrative laws, and that requires that you need some way of routinely assessing that those changes are actually being made, being implemented, and ways to assess and make adjustments as needed. Of course, accountability also comes into play with justice reinvestment, because you want to ensure that the individual players that are making the changes are actually following through on what's agreed upon. So now I'm just going to turn to a brief history of justice reinvestment. One of the reasons I was invited to speak today is on behalf of the Bureau of Justice Assistance, which has engaged in justice reinvestment since 2006. They had been supporting primarily the Council of State Governments and their early justice reinvestment work with states through individual grants. They also, as I mentioned, supported the Urban Institute on experimenting and applying justice reinvestment to the local level. Those experiences and also the successes of the Pew Center on the states led the Bureau of Justice Assistance to launch the Justice Reinvestment Initiative in 2010, just about a year ago. That initiative formalizes justice reinvestment and created a source of technical assistance and funding for states and localities interested in engaging in this work. involves the following partners. I referenced the Urban Institute. We are working with the Bureau of Justice Assistance to coordinate the entire initiative, set performance measures for the sites that are selected to participate in the program, and to document the implementation and assess the impact of the initiative in each of these sites. Justice Reinvestment is also supported by 4 TA providers, 2 on the state level and 2 on the local level. Those are the Council of State Governments and the Bureau Institute of Justice on the state level, and on the local level, the Crime and Justice Institute and the Center for Effective Public Policy. It's also critically important to note that the Justice Reinvestment Initiative involves a public-private partnership in that BJA has partnered with the Pew Center on the States, who, concurrent to BJA's early work investing in Justice Reinvestment, was also investing in this work. And so with the 2010 Justice Reinvestment Initiative, BJA and Pew aligned their efforts, and states that are participating with Pew and or BJA on Justice Reinvestment are eligible to be part of this initiative. So the technical assistance that's provided by those agencies that I described earlier is available to states, counties, cities, and tribal authorities. We describe the initiative as consisting of 2 phases. Phase 1 is technical assistance to get started. And by get started, I mean to support the collection and analysis of data that identifies the drivers of criminal justice costs and helps identify the various policy changes that could be implemented to achieve changes and incur savings that can then ultimately be reinvested. In Phase 2, all Phase 2 sites will have gone through Phase 1, and they'll continue to receive technical assistance, but are also eligible for grant awards to support changes that they make. Now, you might question, why do you need money to engage in justice reinvestment if you're that far along in the process? Wouldn't it be the case that you would have achieved savings through justice reinvestment, and you could use those savings to invest in other more prevention-oriented activities? Yes, that is the ultimate goal of justice reinvestment, but in many, and I would argue even most cases, those savings don't materialize overnight. They're savings that accrue over time, and so this grant support that BJA is offering to Phase 2 sites is designed to essentially to prime the pump to enable states and localities to engage in this more prevention-oriented activities while the larger savings are accruing through other policy changes. And I just did include the website to receive more information on the Justice Reinvestment Initiative. You'll see it here. I can also share it with folks at the end of this webinar. Just to share a little bit about the current scope of work, we actually have 30 sites actively engaged in justice reinvestment at this time, 13 states and 17 localities. The vast majority of those are considered Phase 1 sites, which, as I just described, they're in the process of collecting and analyzing the data, developing those collaborative decision-making bodies, bridging support across party lines, and developing the legislative reforms and other changes to create more cost-effective investments. And then about a third are in that Phase 2 process that I described. So they've already passed legislation or developed and agreed upon strategies and are in the implementation stages of those strategies. Here's just a map to illustrate those sites, and as you'll see, the dots represent the counties and the shaded areas represent the states that are participating. I'm happy to provide a list of these after the webinar. And then I just thought that this is all kind of being described in the abstract, so I just do my best to describe 2 state examples, although I understand that Doug's going to be talking about North Carolina. So Doug, I do not want to steal your thunder. I will just give very broad brushstrokes examples of what happened in both North Carolina and Ohio. North Carolina did, as most successful justice reinvestment states do, passed an actual Justice Reinvestment Act. It had overwhelming bipartisan support. And the act included provisions that would avert prison population increases and save an estimated 3,600 beds over the course of just a few short years, with an estimated $290 million in savings over that period of time. It's a tremendous volume of savings. Of that, $4 million was identified to be reinvested in community-based treatment programs for people on supervision. And if I mischaracterized any of that, I'm sure Doug will correct me. Ohio is another state as the recent success in justice reinvestment. They passed a statute to avert all of the projected prison population growth that they had identified through projection models, and they assessed the savings to be in the realm of $500 million. They also found ways to ease prison crowding, generating another savings of $46 million in just a few years' time. One critical component of the work in Ohio was to adopt a risk assessment tool that would be used throughout all components of the criminal justice system to ensure that the people who need to be confined in correctional facilities are confined, whereas those who are safe to be in the community are safe to be in the community, but also to identify needs of those individuals to target treatment to the right people. Of the savings that Ohio anticipates through this initiative, they have identified over $20 million to be reinvested in the area of probation supervision. So those are just two examples. There's many more, and Richard Jerome, who's on this call from the Pew Center on the States, can share much about other great successes across the country and is perhaps much more skilled at describing the state initiatives than I am. So I'll invite him to do so perhaps later on in the webinar. And that concludes my portion of the presentation.
Great. Thank you, Dr. Levine. And of course, just a reminder to everyone that you can submit a question at any time throughout the presentation by using the chat box. In 2010, the South Carolina General Assembly adopted the Omnibus Crime Reduction and Sentencing Reform Act. J.J. Gentry, a staff attorney for the South Carolina Senate Judiciary Committee, is now going to discuss his role as a staff member of the commission that put forth the Omnibus Act and provide an update on the data collection efforts that resulted from this act. Mr. Gentry?
Hi. Thank you, and hello, everyone. I do not have a PowerPoint, as you can see on the computer, so you can just sit back and listen, and feel free to ask questions later on of me, and I'll give you my experience. As Megan pointed out, I am a staff attorney for the South Carolina Legislature. Specifically, I work for the Senate Judiciary Committee. My area of focus is in criminal law, and just so you know, I am a nonpartisan staff, meaning I work for both Republicans and Democrats on all criminal issues and otherwise. A little bit about South Carolina, for those of you that don't know a lot. South Carolina has traditionally been a tough on crime, lock them up and throw away the key attitude kind of state, which is something that I know a lot of you are familiar with. In the last 25 years, South Carolina has focused more on arrest, prosecutions, and putting people away in jail and locking them away for a long period of time, and has put very little effort into any type of evidence-based practices or into any programs that help to reduce recidivism. Instead, it's been a process of arresting someone, putting them in jail, letting them serve their time, and when they get out, they get back out on the street. And of course, this leads to recidivism. So South Carolina focused on that. It was evident that these type of behaviors and attitudes were not working. In the last 10 years, we experienced a record number of violent offenses, serious offenses, most serious offenses, and a record number of repeat offenders in various areas of the state. We're also experiencing a record number of criminal cases, a record number of inmates in the prison, a record number of people on probation and parole, and as all the states, I'm sure each of you are experiencing a record low in resources to be able to deal with all of these problems we had. And so as a result, a couple of years ago, the state itself decided to establish a sentencing reform commission to try to find out if there are ways we could go about reforming sentencing in South Carolina to solve some of the problems we had with recidivism and other issues. We were able, and very fortunate at the time, to partner with Pew and several of Pew's partners they use to be able to sit down, look at the facts, do research, provide data, look at the evidence, and determine what were the driving forces in South Carolina that were causing us to have so many problems like we were, that were driving recidivism in the state. And what we ended up finding out were there were a number of driving forces. Again, I could not, as a staff member, have been able to undergo this entire sentencing reform process without Pew and the Pew partners. They had the resources, the expertise, the program data, everything they needed to come into our state and give an objective analysis of our existing sentencing system, the Department of Corrections, Triple P, and on down the line, and come back and recommend measures to us based on the data they received. I myself, as a staff member, could not have collected and gathered that data, nor did I have that expertise. So I think a key point in this comment would be that for judiciary staff or for legislative staff, it's important to partner with organizations like Pew and their partner organizations to try to assist you in gathering the data and information, not to mention the fact that we're all cash-strapped right now, and Pew and those organizations provide that service to the states upon qualification at no cost or at very little cost in most instances. So I want to thank Pew and the other partners we worked with. As a staff member, I was involved deeply in all of the hearings of the Sentencing Reform Commission and also in the legislation that was drafted, of which was described a moment ago. It's called the Omnibus Crime Reduction and Sentencing Reform Act of 2010. As you can see with the 2010 name, it was just passed this last year. However, it was a monumental piece of legislation that went into effect almost immediately. The bill itself passed overwhelmingly in the House and the Senate and was signed by the governor with overwhelming support by everyone, which is pretty surprising considering we are a very conservative state and have had a different attitude. But the fact that we came forward with actual data and actual recommendations based on that data, it proved to the legislators that they needed to take a different approach to sentencing and to recidivism. And those approaches are those that we came out of recommendations. Now, since we're focused here mainly on recidivism and reinvestment, one of those driving forces that was determined was that in the Department of Probation, Parole, and Pardon Services, we determined that 24% of all prison admissions were coming from people on probation or parole who were having their probation or parole revoked. So 24% of all prison admissions were coming from revocations. And so most of those, 66% of those, were sent back to prison for non-criminal technical violations as well. They weren't going back to prison because they were committing further crimes. They were going back to prison because they showed up for appointments late, they failed drug tests, and so forth. So the legislature determined in the Omnibus Act that if anything could be done to reduce recidivism immediately, the best thing would be is to change the way what I call Triple P, which is Probation, Parole, and Pardon Service Agency, focused on recidivism. As I told you earlier, South Carolina basically in the past gave a directive to probation and parole and the Department of Corrections to just lock them up, be tough, send them back to jail. Once the legislature passed the Omnibus Act, they changed the mindset of those agencies. New agency heads came in, and those agency heads had to focus on evidence-based practices as required by the law. Now, at first there were some agency employees that didn't agree with that type of philosophy and method, but over the last year they've come to believe in that, and both the Department of Corrections and pardon, probation, and parole are fully on board at this time in South Carolina with using evidence-based practices, with fully implementing sentencing reform, and with doing something about recidivism. One of the portions of the Omnibus Crime Reduction Act that we passed basically established an oversight commission, of which I serve on the staff as well. And that oversight commission was tasked with making sure that the agencies were following through with implementation of sentencing reform measures. I think this is very important to have an oversight commission after you have major legislation passed, to make sure that the agencies are accountable to the legislature and to all the powers that be, and make sure that they're following through. Triple P, Pardon, Probation, and Parole, and DOC report back to the Commission on their implementation of all of the sentencing reform measures. For instance, the Triple P has put into place, Pardon, Probation, and Parole has put into place a new system of administrative sanctions. Instead of just arresting someone and sending them back to jail for a technical violation, instead they receive administrative sanctions and a points violations. The next big measure that our parole and pardon services and also the Department of Corrections have been involved with is, as discussed by the previous speaker, the Justice Reinvestment Initiative. We had, before we even heard about the Justice Reinvestment Initiative here in South Carolina, we had already put into place legislation that essentially accomplished all of the goals of Phase 1 of the Justice Reinvestment Initiative. So at the time we applied for any type of assistance, we were applying for Phase 2 implementation of all the sentencing reform measures. One of those measures was to try to get the Justice Reinvestment Initiative grant funding to our state, and also to get someone to give us technical assistance in implementation of the laws. As was described earlier, someone might ask, well, why didn't you just budget it in your state budget? Well, the states are cash strapped, plus it takes about a year to go through a fiscal cycle. So in order to get funds to start up programs within Triple P and DOC dealing with justice reinvestment, we're relying heavily on the grant funding to come in so that we don't have to wait a year to go through the next fiscal cycle. The other thing that our Pardon, Probation, and Parole, and also the DOC has established is a new actuarial risk and needs assessment instrument. They've implemented that into effect. Now, it's only been a short time since the new law has gone into effect, since 2010. I just recently did an analysis of how all of these strategies for dealing with recidivism are actually starting in the initial phase to give us some numbers, like how is it being implemented and what are the statistics early on. And I do want you to take into account these are early numbers, but they're all positive in our aspect. We know that the violent crime rate statistics are down. Our prison population is down between 2,000 and 3,000, when years before it was increasing 2,000 to 3,000 a year. The Triple P, Pardon, Probation, and Parole, after implementing all of these reinvestment strategies they've used, have actually reported an 18% reduction in compliance revocations, a 12% reduction in supervision revocations, 13% reduction in compliance revocations, and I can continue to go through each of these numbers, but overall we're looking at about a 15 to 20% reduction in revocation areas that are not going back to prison. These are people that are not having to go back to jail. Instead, they're continuing with their probation and parole and becoming more productive citizens. Now, what does that mean? That has come out to be what we estimate to be a cost savings to our Department of Corrections of a little over $1 million in this short period of time, less than a year. As a result, our Sentencing Reform Oversight Committee that I staff made a recommendation to the General Assembly last week that the General Assembly take that $1 million that's been a savings and reinvest it into the Department of Probation, Pardon, and Parole to be able to be used specifically for reinvestment of programs that Triple P wants to do in order to reduce recidivism. For example, they want to set up a violations and incentives matrix. We don't have a youth offender supervision program, so they want to set up a youth offender supervision program. They also want to set up a service provider model. We spend a lot of money on service providers as a state, and also the people who participate spend a lot of money. And so they want to set up a service provider model that can be used throughout the state, and also use some of the funds for victim services and community partnerships to understand more about recidivism and how reinvestment works and how evidence-based practices work. But we made, as a committee, this recommendation last week in a report called the State Expenditure Savings Report, and I'd be glad to provide it to anyone. And that report shows these initial numbers are very positive, and also shows to our legislature that all of these strategies are working. Now the key is, as a staff member, I'm working closely with our finance people in the legislature to make sure they are committed to putting the money that is being saved back into these programs that essentially are our sentencing reform measures. And that's going to be a big goal of mine as a staff member, is to stay involved in oversight. Since our legislature is not in session all year, they will be back in session in January. And at that time, the Oversight Committee, I will be working with them on issues dealing with amendments to the Omnibus Act, and also dealing with keeping up with these agencies, being that liaison person that can basically report between our Oversight Commission, the legislature, and between the agencies as a whole. I'll be glad to answer any questions once the presentations are through. If there's anything you have questions about or any information you can send, I would be glad to. Thank you.
And thank you, Mr. Gentry. And Mr. Gentry did allude to the State Expenditure Savings Report, and that will be available online after this webinar for anyone who is interested. Our final speaker is Douglas Holbrook, and he is a fiscal analyst for the North Carolina General Assembly, where he works on courts and corrections issues. He also helped design the data collection capacity of the North Carolina Sentencing Commission when it was established in the early 1990s. Part of his work during the past legislative session was on the Justice Reinvestment Act, which is projected to save the state $290 million over the next 5 years. Mr. Holbrook?
Yes. Okay. I'll just, begin, I'm on the fiscal staff, and like Mr. Gentry in South Carolina, I am nonpartisan central staff, staffing both House and Senate Appropriations Committees, Democrats and Republicans, all 170 members of the General Assembly. And I do the specific areas in the budget are probation, community corrections, indigent defense, and courts. We started off this process, I suppose, a session ago in 2010 when we had a visit from Jerry Madden, who is a component, who was one of the real leaders from Texas in getting justice reinvestment working there. And Pew helped to bring him to us and talked about what was going on in Texas and how we might look at our system. A lot of the kinds of reforms that you've heard about from South Carolina were North Carolina began making some initial steps in that regard in the early 1990s with our Structured Sentencing Act, with the creation of our Sentencing Policy Advisory Commission that continues to this day to pull together from all the different data sources in our criminal justice system, brings together a database of sentencing information from the courts and the corrections department, and we use that at the legislature to do a fiscal analysis on any bill that might have an impact on the correctional system. So the Sentencing Commission's presence made the involvement of the Council of State Governments just a really good, and Pew made it a really good partnership for us. We had some of the initial stages already done when we began the work, but our Sentencing Commission had just volumes and volumes of data available just to transfer, just for the folks to begin working on. And my principal concern in looking at this sort of thing is the fiscal. And it made it really possible for us to look at the potential impact of what was going to happen by doing more sentencing reform, looking back at our system. To pick up on some of the facts of why we were really interested in looking at this, our admissions to prison were, unlike South Carolina, ours were 50% for revocation of community punishment. So 50% of the admissions to prison were coming from people who were failing on probation, and 70% of that 50% were purely for technical violations. So it was not new crimes, it was missed office visits and curfew checks and so forth. So that was a significant problem. And over the last 5 years in North Carolina, all of our criminal justice indicators like arrests and filings and so forth have gone down about 9%. And yet the prison population has not gone down. Nothing has changed. It has gone up a little bit, in fact. And that is probably a combination of two factors. One of those being that the steady increase in revocations of probation, the other being that we had a habitual offender law that would sentence offenders, many of whom had been convicted of very low-level felonies, 3 low-level felonies, would then sentence them as what we would call a Class C offender, which is 1 level down from second-degree murder, at the same level as first-degree burglary and first-degree arson. So these people, there were high volumes of them, and they were staying in for a very long time, generally in excess of 10 years. So we began working and with the folks. They were pulling data from the Sentencing Commission and working together with our Sentencing Commission staff, which is part of the judicial branch, actually, not part of the legislative branch, and they are a research commission, an excellent thing we have here in North Carolina. So we were able to put together a fiscal analysis of each of the recommendations of the, or some attempt at a fiscal analysis of each of the recommendations that came from the Justice Reinvestment Initiative. And I mean, some of the problems that we did have in dealing with, there are certain proposals that are completely new policy for us. There's one of the elements of the bill was something called advanced supervised release, which would provide that if an offender, having been sentenced under our sentencing law, the judge would sentence them to not less than X nor more than X 120% of X months, would allow the offender to get out in less than X months if they complied with conditions in probation and in prison, complied with conditions, and if they completed treatment while they were in prison. That is a complete departure from our general sentencing philosophy, and there's really no way to project what it would do. So that is one of the things that it's uncomfortable as a fiscal analyst to say, well, we don't have any information available, but that doesn't mean there's no impact. So that made some real complexities in dealing with the fiscal analysis. We'll just do a kind of a brief overview of the sections of the bill that we went through and how it relates to sentencing correctional policy and also recidivism reduction. The first two sections of the bill deal with community supervision, both probation and post-release supervision, and they basically increase a statute we already had in existence called delegated authority, and it gives to the probation and parole officer the authority to implement certain conditions, additional conditions of supervision without a return to modification of the order by the judge, so that the officer can respond very quickly to misbehavior of the technical variety. So the most significant of those was officers are now able, where the judge has delegated the authority, to actually have an offender locked up for up to 3 days at a time in jail in immediate response to a technical violation. The offender also has to waive their right to hearing at the beginning of their probation sentence. So this means that the probation officer has the ability to wield a much more significant hammer and a much more immediate one than saying, well, you keep doing this and we'll take you back to court and the judge can revoke you. So this does increase admissions to jail, but is probably not affecting the population overall. And this is true for both probation and post-release supervision. These sections of the bill also require that we have a much more comprehensive risk and needs assessment to be done on all offenders entering probation, because previous to now, we have had a distinction between community and intermediate offenders. That has been done away with, and so the use of sanctions within the conditions of probation is now entirely in the professional discretion of the probation officer based on risk assessment. So those are two very significant changes. Furthermore, we have changed the overall power of revocation so that if an offender is at a revocation hearing for technical only violations, his revocation period is limited to 90 days, as opposed to the imposition of the entire sentence length, unless it is for a new crime or for absconding on probation. So the hope with that is that it will certainly reduce the amount of time people stay in on revocation, so that you don't have as much stacking effect of offenders on revocation. And then we've also made some effort at revising our habitual felon statutes and to make it more flexible for the district attorney to, rather than all offenses on habitual status going to a Class C felony, they would actually go up a number of classes over what the triggering offense was. We have expanded a felony drug diversion program so that first-time drug offenders have to have a deferred prosecution period and of supervised probation, and during that period they can actually get the deferred prosecution to be subsequently dismissed. And there's also, as far as reinvestment, North Carolina has had a state-county criminal justice partnership program ever since 1994. It started off as a $12 million grant fund. It came down to about $9 million a number of years ago. And it has been funding day reporting centers and satellite substance abuse programs in the 100 counties of North Carolina over the years. The Partnership Act was repealed as a part of this legislation. The money was left alone, and it was converted to a more directed fee-for-service contractual treatment basis, so that those $9 million are now tied to individual offenders. The Department of Correction can now engage in contracting efforts to get very specific services provided at with more variety than just giving a county a grant, and the county then would determine what they would do with their grant funds. So all of these things, I should point out, are coming into effect now. This bill passed in July, or June rather, and so will not be effective really until throughout 2012. Various aspects of the legislation will come into effect. And I should also have mentioned that one thing that changed in this bill also was to move most misdemeanors into the state, into county jails instead of the state prison system. North Carolina had been taking revoked misdemeanors into the prison system, sometimes as many as 1,200 in any given day, which was a large number, and so the effort was made in this bill to shift those back to county jails. And this was really the most complicated part of getting this legislation passed, because the counties, who are probably as cash-strapped as the state didn't want to take on the responsibility of 1,200 more inmates in their overcrowded jails. And so we had to work out a rather sophisticated financing plan for the counties to transfer direct fees into the counties to help cover those costs in the amount of about $30 million. So that's essentially what went on there. There was a lot of intergovernmental relations lobbying that went on between the counties, the district attorneys, and so forth. So unlike Mr. Gentry, I can't really give you much in the way of outcomes yet, because the law has not actually become effective until January 1st, and does not, so we wouldn't begin to see any results from this Justice Reinvestment Act yet. And I would also need to mention that another legislative action from this past year was to combine our departments of adult corrections, juvenile justice, and crime control and public safety into one mega agency of public safety. So at the same time that our folks in community corrections and prisons are trying to figure out how to implement these policies, they're also being shifted into a new agency. Many of the leadership have actually, because their top management have lost their jobs, people are retiring, so there's just a whole lot going on in the realm of justice around this. So they're, you know, really struggling to make it all happen. But that is the current status for North Carolina, and I too will be happy to answer any questions about the bill or about the process. But again, at this time, it has not been in effect enough for me to give you any results or outcomes.
Very much, Mr. Holbrook. And today we have had a plethora of great information presented, but unfortunately we are not going to have time, out of respect for your all's time, to answer Q&A. We have received some questions so far, and we will be responding with answers to those questions that we received via email. And if you have any further questions, Allison Lawrence here at NCSL's contact information is up on the screen. Please feel free to contact Allison with any additional questions. We would like to thank again our speakers, Mr. King, Dr. Levine, Mr. Gentry, and Mr. Holbrook, and also another big thank you to our partners, the Bureau of Justice Assistance and the Public Safety Performance Project, and of course a thank you to all of our participants for your time. Please remember that an archive of the webinar and related resources will be made available shortly, and you'll be able to find that on NCSL's Criminal Justice webpage. Thank you all for participating today, for your time, and have a great holiday season.